Carlos became a U.S. citizen in 2018, and he went through everything: the application, the civics test, the oath ceremony. He built his entire life around that citizenship. Then, in 2026, the Trump administration announced that denaturalization, stripping U.S. citizenship from people who already have it, was a national priority. Carlos got a letter from the Department of Justice. His case had been opened. Now he's terrified. If you're a naturalized citizen and you've been scared about losing your status, you're not alone. My name is Magda Cuprys, and I'm an immigration attorney in Florida. I'm going to tell you exactly who is at risk and what your rights are. Let me start by saying something that I think a lot of people need to hear right now. The fear you're feeling is real, and it makes complete sense. The Trump administration has been very public about using every legal tool available to remove people from this country. And denaturalization, which means taking away citizenship from people who are already naturalized, is one of those tools. But fear without information is dangerous because fear alone can make you do things that actually hurt your case. So let's slow down and talk about what denaturalization actually is, what it isn't, and who is genuinely at risk. What denaturalization is. Denaturalization is the legal process by which the federal government revokes someone's U.S. citizenship. You become a citizen through naturalization, meaning you were not born here. You applied, you qualified, you took the oath. Denaturalization reverses that. It is not new. It has existed in U.S. law for a very long time. But historically, it has been used rarely and in extreme cases. What the Trump administration has done is expand the resources dedicated to finding and pursuing these cases. The Department of Justice now has a specific unit focused on denaturalization. That is new. So more cases are being opened, but that does not mean everyone is at risk. The law still requires specific legal grounds. The government cannot simply decide they don't like you and take away your passport. There have to be reasons. The three main grounds for denaturalization. Let me walk you through the three main reasons the government can move to denaturalize someone. The first is fraud during the naturalization process. This is the most common one. If you lied on your application, if you concealed something that would have disqualified you, if you submitted false documents, the government can come back and say your naturalization was obtained illegally. It doesn't matter how long it was. There's no statute of limitations. This is important. The government is now using modern databases and digital records to go back and re-examine older applications. Things that weren't caught in 2005 or 2010 are being flagged now. The second ground is membership in subversive organization. If you were a member of an organization that advocates for the violent overthrow of the U.S. government and you concealed that during your naturalization process, that can be used as grounds for denaturalization. This one goes back to Cold War era laws, but it is still on the books. The third ground is certain criminal convictions. Some serious crimes, particularly those involving treason or offenses committed within 5 years of naturalization, can trigger a denaturalization review. This is less common, but it exists. Here's the bottom line. If you were honest on your application, if you did not hide criminal history, if you were not a member of prohibited organizations, your citizenship is not in serious danger. The fear is bigger than the actual risk for most people. Administrative versus judicial denaturalization. What's the difference? There are two ways the government can pursue denaturalization, and it matters which one you're dealing with. Judicial denaturalization is a court process. The Department of Justice files a civil lawsuit against you in federal court. You get notice, you have the right to an attorney, you have the right to present a defense. A federal judge makes the decision. This is the more formal, more protected process. Administrative denaturalization is different. Under certain circumstances, the government can revoke citizenship through an administrative process without going to federal court. This is faster and offers fewer immediate protections. It applies in specific situations, primarily cases where someone was naturalized through fraud or misrepresentation that is very clearly documented. The reason this matters is that the Trump administration has been pushing to expand the use of administrative denaturalization to move faster and handle more cases. If you receive any kind of notice from USCIS or the Department of Justice related to your naturalization, you need to understand what your process is and what your rights are at that stage. What to do if you receive a denaturalization notice. I want to be very direct about this part. If you receive any communication from USCIS, the Department of Justice, or any federal agency that references your naturalization, your citizenship, or your status as a U.S. citizen, do not ignore it. Do not assume it's a mistake and put it in a drawer. Do not try to respond to it yourself without understanding what it says. The first thing you should do is read it carefully and write down exactly what it says and when it was sent. The second thing you should do is talk to an immigration attorney as soon as possible. Not eventually, not when you have time, soon, now. Here's why. The government sets deadlines. If you miss a deadline to respond, to request a hearing, to file a defense, you lose rights that you cannot get back. The sooner you get legal counsel involved, the more options you have. Your rights during the denaturalization process. I want to be very clear about this because I think a lot of people don't realize it. If the government tries to denaturalize you through the judicial process, you have constitutional protections. You have the right to due process. You have the right to be notified. You have the right to contest the case in court. You have the right to present evidence on your behalf. The government has to prove its case. You're not automatically stripped of anything just because they opened a case against you. Even in the administrative process, there are opportunities to challenge what's happening, but you have to act. Silence is not a defense. The Trump administration has made denaturalization a stated priority. That is real. But there's significant difference between the government having a priority and the government successfully denaturalizing someone who followed the rules. If you went through the process honestly, you have more protection than you think. The fear is real. The risk depends on your situation. I want to end this section the same way I started. The fear is understandable. The anxiety that naturalized citizens are feeling right now is completely valid. The news is alarming. The rhetoric is alarming. But panic doesn't protect you. Knowledge does. Understanding what the government can actually do, what the law actually says, and what your rights actually are, that is what protects you. Most naturalized citizens are not at serious risk of denaturalization. But if you are in a situation where you have something in your past that you didn't disclose, or you have reason to believe your application had errors, or you've already received some kind of notice, do not wait. Talk to an immigration attorney who handles these cases. The earlier you get help, the better your position. If you have questions about denaturalization or your citizenship status, leave them in the comments. I read them, and your questions may help someone who's scared and watching this video right now. Subscribe if you want to keep getting real, honest information about what's happening in immigration law. I post regularly, and right now, more than ever, you deserve to understand your rights.